When speaking with potential new clients, one of the questions I am very frequently asked is if they go ahead and sue the person that has abused them or an institution that could be liable for the abuse, if they'll have to use their own names. In civil cases, the answer generally is yes, you will have to use your own name, because unlike the criminal system, where publication bans are intended to protect the identity and privacy of a victim, in a civil case, it is for the most part assumed that you will use your own name. If a plaintiff doesn't want to use his or her own name, there are a number of options. The most common would be to use a pseudonym, either putting down the name Jane or John Doe instead of your own name, or using only your initials. In either case, you have to get an order from a court to permit you to go ahead on that basis. And in order to get that order, you have to meet a three-part test. First, they have to demonstrate that there's a serious issue to be tried. Second, that without the order, they will suffer irreparable harm. And third, that the balance of convenience, which is a legal test that relates mostly to public policy, favors granting them an order for the pseudonym or their initials. To satisfy the first step in the test for obtaining a pseudonym, you have to demonstrate that there's a serious issue to be tried. It's a low threshold, and in cases of sexual abuse or sexual assault, this will generally always be met. To satisfy the second step, you have to prove that you will suffer irreparable harm if you are not granted an order protecting your identity. Irreparable harm doesn't mean embarrassment. It means that you will suffer serious medical or psychological harm if your identity is not protected. You need the evidence of an independent party, like a physician or a psychologist, to demonstrate that you will suffer these harms. To satisfy the third step in the test for obtaining a pseudonym, a plaintiff must demonstrate that the balance of convenience weighs in favor of granting them the order. The courts look at a number of policy factors in making this decision. In particular, they will look at the principle of open courts. We believe that our justice is better when it is open and transparent. The court will also look at factors specific to the plaintiff and defendant. For plaintiffs, the courts will consider the fact that protecting a victim's identity leads to increased reporting of crimes of sexual violence, and they'll look at protecting the plaintiff from possible further trauma if their name is used. As for defendants, they will look at whether there's any impact on the defendant's ability to mount a robust defense. No, not all plaintiffs want to use pseudonyms, and in fact, most don't. Often by the time someone is ready to bring a case seeking justice and compensation for sexual abuse or sexual assault, they are ready to confront openly what has happened to them, and they are finished with being ashamed and hiding the past.